Good day, and welcome to Lawyers and Friends. I'm Melissa Day, and this is
Melanie Daly.
And sorry we're a little late, but we were just talking about an enraging hearing that I had the other day. Before we get underway here for part 3 of our Lawyers and Friends installment for Dr. Sue's, I just want to let you know that this is attorney advertising and prior results do not guarantee similar outcome, and that if you shouldn't construe anything that you hear today as being legal advice, this is primarily for entertainment purposes.
We are entertaining.
Oh yeah, and you may have noticed my hair is a little different today. If you have an issue on a third-party action, I would recommend strongly that you reach out to defense counsel, and if you want to get the best counsel around, then you would reach out to us. So let's get going. We're going to talk today, and we're going to look at some examples. You do not need to answer questions today, so you don't need your smartphone. However, if you have a calculator on your smartphone, you could grab that, or grab some other calculator and a pad of paper, because I am going to make you do some math. So hopefully you're well nourished and your brain has some energy and some fuel in order to do some calculations with us. We don't have a ton of examples, but we're going to go through them step by step so that we can illustrate the the premises and the features of the types of third parties that you'll encounter as we go through the calculations. So let's just do a super quick review. For a recap, we're going to remind you that for every one injury, I should have changed, it's been the third time now, I should have changed this typo. For every one injury, there can only be one recovery. So just remember that. If somebody falls down and rips their meniscus at work, that's an injury, and you can only get one recovery for that. Slide. The challenge in workers' compensation is if somebody was negligent and caused you to slip, like there's ice in a parking lot, and so you slip and fall, you could have two potential avenues for getting that one recovery for that one torn meniscus. And the two potential recoveries are, you could file for your workers' compensation benefits if it happened at work, and you could also pursue a third-party action against a negligent third party. Okay, but you can't keep both recoveries. You can only get one recovery for one injury. And so Section 29 is the mechanism by which, slide please, we ensure that an individual only gets one recovery for that one injury. There are two methods under Section 29 which assist us in preventing double recoveries. And what are those, Melanie?
The credit, or the offset or holiday, and a lien.
Okay, and you get a lien against the recovery from a third-party action for what?
For the past payments.
And you get a credit against what?
Future payments.
Okay, very important. By this time, I hope that everybody has this drilled in your head, and that you will not refer to a carrier or employer's rights in the future following a third-party action as a lien. And you also will not refer to a credit, offset, or a holiday in order to describe a carrier or employer's rights for recovering past benefits paid. Liens are for past benefits, to recover past benefits, and credits are to prevent a double recovery by giving the carrier or employer a holiday against future benefits. Slide. Our production team is so amazing.
Yeah.
Thank you, Max and Justice. So the claimant and the carrier, so then we talked about attorney's fees, because if there's an area of law where there's going to be a lot of litigation, it's going to be a fight about attorney's fees. Because you get a couple of attorneys fighting about money and just wind them up and let them go. The carrier and the claimant, since both can potentially benefit, well, the claimant can potentially benefit, the carrier always stands to benefit when there's a recovery. But because the claimant and the carrier can both benefit from a third-party recovery, they have to pay the costs associated with the benefit that they receive. Sometimes, if you know the benefit that the carrier and the claimant receive at the time of the settlement, you can determine what the costs associated with that benefit is going to be. However, at the time of the recovery, when the attorney from the third party is paid, right? Like They're going to get paid when the defendants fork over the money for the negligence that they caused as a result, to settle the case and to get releases from the claimant. The attorneys for that third-party recovery, they're going to get paid then. All right, so those attorneys get paid. However, and at that time, we may not know if the claimant is going to benefit or if the carrier and the claimant are going to benefit from the settlement. And so we may not be able to determine the relative sharing of the costs, the third-party attorney's costs, fees. We may not know that at the time of the settlement. And that's what a lot of the issues that arise in third-party settlements pertains to. Slide. So let's take a look at a situation where we have known benefits at the time of the third-party recovery. If the benefit that each party is going to receive is known at the time of the third-party settlement, then we can determine the costs that the carrier or the claimant and the carrier are going to have to pay, because you assess what their benefit is and then you assess the costs associated with that benefit. Slide. Let's take a look at a couple of examples of known benefits at the time of a third-party recovery. This right here is a blank worksheet that I would like you to fill out here. This is where we're going to start to do some math, okay? So here's our hypothetical situation. We have a claim where there's a gross settlement in the amount of $600,000 from a third-party recovery. We're just going to assume for purposes of this example that there's zero disbursements. So the plaintiff's attorney didn't have to pay for any copying or postage or experts or court reporters or subpoenas for medical records. They didn't have any disbursements in connection with obtaining this $600,000 settlement. Assume that it's a regular 1/3 contingent fee arrangement for a plaintiff's attorney. They get a 1/3 fee on whatever recovery they get for their client. And also assume that we have a lien of $120,000. And that lien is all that's ever going to be paid on this workers' comp claim, because the case settled by way of Section 32 agreement. So for our purposes, you don't need to know what the payments were before the 32 and how much the 32 was. Just assume that all the liability on the file, whether it was payments before the 32 or the 32 itself, all of those payments amount to $120,000. There's no future benefit on this claim to the carrier because why?
It closed in the 32.
Full and final closure. There's no future liability to the carrier. So the carrier could not possibly have any future benefit from this $600,000 because the carrier doesn't have any future liability. All right, so let's go through this and let's do the calculations. With a gross settlement of $600,000, Melanie, what are the attorney's fees going to be for a $600,000 recoverment, assuming a 1/3 contingent fee arrangement?
That would be $200,000.
Okay, so I'm going to put that right in my little chart here. So we said we have $0 in disbursements, and the highlighted lines here on your screen are the items for which you would have to be provided information in order to be able to perform these calculations. So we have $0 in disbursements. What is the total cost of litigation for obtaining this recovery?
Total costs would be the $200,000 because
Correct.
0 disbursements.
Exactly. Okay, so total costs would be your attorney's fees plus disbursements. In our example, because there are 0 disbursements, it's going to be the $200,000 for the fees. So it's $200,000 basically plus 0 equals $200,000. Percent cost of litigation is calculated by taking the costs and comparing it to the total amount of the settlement. And you're trying to figure out what percent of the total settlement are costs. And so in order to do that, you take $200,000, which are the fees and disbursements, and you divide that by the total recovery. And that will give you the fractional amount that the costs are to the total settlement. And what will the percent cost of litigation be in our somewhat simple example?
33.3%.
Correct. Okay, so $200,000 divided by $600,000 equals 1/3, or 33.33333, repeating percent. To calculate the net proceeds available to distribute, you're going to take the gross amount of the settlement minus the attorney's fees. Okay, so it's just a fancy way of saying, like, after the attorneys are paid, what's available to distribute to the claimant and the carrier. And here we would have $600,000 minus $200,000. So we have a total amount available to distribute after the attorneys have been paid of
$400,000.
$400,000. Great. Assume for our purposes of our illustration here that we have a lien of $120,000. To calculate the carrier's cost for its lien recovery, you take the lien and you multiply it by the percent cost of litigation, because it's going to be the carrier's benefit is going to be you're going to pay for that benefit in the same proportion that the costs are to the total recovery. So it's like if you're setting up an equation, you're doing like 200 over 600 equals X over 120,000. Right? And you basically solve for X. And the way you can do that is to take the lien, 120,000, multiply it by the percent cost of litigation. And so what is the carrier's cost to recover its lien going to be?
$40,000.
$40,000. Terrific. And that leaves how much left over of the carrier's $120,000 lien for it to recover?
$80,000.
$80,000. Perfect. It's like you studied. Slide. Okay. And that is the correct answer. So going through all that math, we had a gross settlement of $600,000. The attorney's fees on a 1/3 contingent fee arrangement will be $600,000 times 1/3. We had $0 in disbursements, so our total cost of litigation in this example was $200,000. That means that the percent cost of litigation is also 33 1/3%, because you take $200,000 and you divide it by $600,000. Proceeds available to distribute to the claimant and to the carrier is your gross recovery minus the costs. And in our example here, $400,000. Assuming a lien of $120,000, the carrier has to pay for its benefit of recovering its lien in the same proportion that the costs are to the total recovery. And so the carrier reduces its lien by 1/3. And so to figure that out, you take $120,000 times the percent cost of litigation, which is 33.33%, and you come up with $40,000. Subtract that from the recoverable or the total lien, and you get the carrier's recoverable lien of $80,000. Easy, right?
Easy.
It's totally easy. All right, let's take a look at another example. So this is another example where you have a known benefit. And remember, what we said was if it's a known benefit, you should be able to determine the party's costs at the time of the third-party recovery. Okay, so for purposes of this example, we're going to assume that we have a gross settlement of $150,000. We're going to add in disbursements on this example. The disbursements are $5,000. And assume that we have a lien of $300,000. So if we have a lien of $300,000 and we only have a gross settlement of $150,000, what kind of a claim is this?
Deficiency.
Okay, and it's called a deficiency claim because what it means basically is that the third-party recovery is deficient compared to the workers' compensation claim. Okay, it is insufficient to exceed the full value of the workers' compensation claim. The deficiency comes up once the deficiency has been exhausted, then the carrier has to start paying again, basically. So we have a gross settlement of $150,000, disbursements of $5,000, and a lien of $300,000. Assume again a 1/3 contingent fee arrangement. What are the attorney's fees going to be?
$50,000.
Great. How'd you do that?
1/3 of $150,000.
Right.
So divided by 3.
Excellent. So our attorney's fees are going to be $50,000. What are our total costs of pursuing this litigation?
$155,000.
Not $155,000.
I mean, yes.
Not 100. Attorney's fees are how much you just told me?
I'm sorry, $55,000.
$55,000. And how did you calculate that?
By adding the disbursements to the attorney fees.
Excellent. Okay, so our attorney's fees are $50,000. Our disbursements are $5,000. Those two things added together amount to $55,000. That is what we had to pay in order to get $150,000. $55,000. What's the percent cost of litigation?
36.7%. I don't know what you're talking about.
The percent cost of litigation is 36.7%. And how did you get to that number?
Because you added the 33.3% to the disbursements, or the disbursements to the attorney fees, so it increased it by 3.7%.
Correct. So you add the 5,000 to the 50,000, you get 55,000, and you divide 150,000 by the $55,000, and that will give you the percent that 55,000 is of $150,000. So divide 55,000 into 150,000, and that gives your cost of litigation of 36.7%. And our net proceeds available to distribute. How much do we have available to distribute to the claimant and the carrier after deduction of the attorney's fees?
That would be $95,000.
Excellent. And how did you get that?
Because you took the 36.7% off of the total recovery.
Okay, correct. So you deducted the 50,000 and the 5,000 from the gross recovery of 150,000. And Melanie's absolutely right that if you calculated your percent cost of litigation correctly and you multiply that by your gross settlement of 150,000, that will give you
$95,000.
It'll give you 55,000, which you then subtract from the 150,000 to get 95,000.
Thank you.
Correct. So to get your net proceeds available to distribute, take the gross amount of the settlement and you subtract the total cost of litigation. So the attorney's fees plus disbursements, subtract that from the gross settlement. All right, so we have $95,000 to play with. We have a $300,000 lien. So what's the carrier's cost for lien recovery going to be?
The cost for lien recovery is going to be $55,000.
And how did you get that? And why did you come up with $55,000?
Because that is the 33.3%.
It's the 36.7% of the total recovery.
Yeah, so the total recovery.
Okay, so in this example, because the lien is $300,000, the workers' comp claim exceeds the value from the third-party settlement.
Yes.
Okay, and so that means that the carrier should get the full benefit from the third-party settlement. The claimant gets a big fat zero from the settlement. Okay, so all of the settlement is available only to satisfy the carrier's lien. It's insufficient to satisfy the carrier's lien, but everything that's available from the third-party settlement should go to the carrier. So the carrier's cost for the potential lien for its lien recovery will be the lien or benefit times the percent cost of litigation. In this example, the benefit is $150,000, the full amount of the settlement. And so to pay for that $150,000 benefit, you multiply that by the percent cost of litigation, which is 36.7%, in order to get the carrier's potential, and I'm using language very carefully here, but you get the carrier's potential recoverable lien of $95,000. Okay, so let's just flip the slide and we'll just go through that again real quick. Gross settlement of $150,000, assumed disbursements of $5,000, and a lien of $300,000. Our attorney's fee is a 1/3 contingent fee arrangement. Total costs in securing a $150,000 recovery is $55,000. That $55,000 expressed as a percentage of the overall recovery is 36.7%. And you get that by dividing $150,000 by $55,000. The net proceeds available to distribute to the claimant and or the carrier is $95,000. That's how much is left after the attorneys are paid, because the attorneys are paid first. If your lien is $300,000, it means that the workers' compensation claim is worth more than the third-party recovery, and the entire benefit from the third-party recovery inures to the carrier's benefit, which means also that the carrier pays 100% of the costs associated with that recovery, or the $55,000, which is fees plus disbursements. Therefore, the carrier gets, after that recovery, a total of $95,000.
Easy.
Easy peasy. Okay, now let's make it a little more difficult. I do want to go through this example, but we're going to go through it together, and we're going to go through it together with all of the numbers presented to you, because I want to make sure that everybody has a full understanding of how you calculate your future, the costs associated with a future benefit. Okay, so in this example, we have a known benefit on a non-deficiency claim at the time of the third-party recovery. Okay, and in a hypothetical way, the way you could know that is if your claimant has already been classified with a PPD prior to your third-party recovery, and you have an MSA that is CMS approved, so you know exactly what your future medical costs are going to be. You could have a known benefit at the time of the recovery. Okay, so that's the example that I want you to be thinking of as we're going through this example here. We have known benefits at the time, known future benefit. Well, we have known past benefit because the past benefit's always known, but we also have a known future benefit in this example. So because the benefits to the parties are known, we will be able to calculate what share of the total attorney's fees the claimant should bear versus the carrier. So in this example, assume we have a gross settlement of $600,000. Our disbursements are $12,000. Okay, our lien is $150,000. So I'm skipping down on our row here. So gross settlement is $600,000. Skip down to disbursements. We know is $12,000. Our lien is $150,000. That's for past benefits paid. Assume we have a future indemnity that's going to have to be paid of $150,000 as a result of a PPD finding. And we have future benefits for medical that is known because we've had a CMS approved MSA of $60,000. Okay, those are all the pieces of information that you need to know in order to go through this example. So if a gross settlement of $600,000 and it's a 1/3 contingent fee arrangement, how much is our attorney's fee?
$200,000.
$600,000 times 1/3. Okay, if our disbursements are $12,000, to calculate the the cost of litigation, the total cost of litigation, what do you do?
Add the disbursements to the attorney fees.
Which in this case will total
$212,000.
Excellent. And then to figure out the percent cost of litigation, because the parties have to share the same ratio, right? So they should have to pay costs at the same percentage. To figure out the percent cost of litigation, we're going to do what?
You divide the gross settlement by the cost of litigation.
Correct. So $600,000 divided by $212,000 comes out to, and it's actually 35.33333%. And so if you're doing the math at home, you should keep that repeating decimal because it does affect our numbers a little bit later in the example. Okay, so our percent cost of litigation is 35.33% repeating. To calculate the net proceeds that are available to give to the claimant and the carrier or to the carrier is $388,000. To get that number, take the total recovery, $600,000, pay the attorneys, pay the disbursements. So you take $600,000 minus $200,000 minus $12,000 to get $388,000. So the carrier and the claimant can share in $388,000. That's what's available in order to benefit the claimant and the carrier. Well, the carrier gets first dibs. They get their lien repaid, right? But they don't get their lien repaid without paying the costs associated with that lien recovery. How do you figure out their costs associated with the lien recovery?
You multiply the $150,000 by the 33%.
35.3%. Correct. Right? And you come out, and if you do it with the 3 repeating, you'll get that the carrier's cost for recovering its lien is $53,000. So $150,000 multiplied by the percent cost of litigation gives you $53,000. To come up with the carrier's recoverable lien, take the total lien minus the cost associated with recovering that lien, and you get $97,000. So $150,000 minus the cost associated with recovering the lien of $150,000 gives you the carrier's recoverable lien of $97,000. Incidentally, what now is available to the claimant and the carrier as a benefit once the lien's been repaid? How do you figure that out? This.
Yes.
You take the net proceeds available.
Yes.
And you're going to deduct what the carrier's going to get back in its lien recovery.
So the 150 and then 97.
Right. So now, and I kind of threw Melanie for curveball again. She handled it beautifully. out of the park. So once the carrier's lien gets repaid, once the carrier gets its $97,000, we no longer have $388,000 available to us anymore as a credit, right? Because the claimant's repaying that. So to figure out what the potential credit is going to be, you would take the $388,000, which is what's left after the attorneys get their fee and disbursements get paid, and then carrier gets satisfied next on its lien. So you would subtract from the $388,000 the $97,000 that the carrier is going to get back on its lien. Okay. Assuming that the carrier's future indemnity is $150,000 and its future medical is $60,000, and we have sufficient credit to give the carrier its entire benefit for the future medical and for the future indemnity. How much is the carrier's attorney's fee going to be on not having to pay future indemnity benefits of $150,000?
Be $53,000.
Correct. Okay, so you're going to take your future to figure out what the carrier's costs are associated with not having to pay $150,000. Right? That's the value of their credit on the indemnity for this. They're not going to have to pay $150,000. To figure out the fees that they have to pay to get that $150,000 benefit, you're going to multiply the benefit by the percent cost of litigation again, that same 35.333 per repeating percent, because everybody pays for the benefit they receive based on the same proportion. So you would multiply $150,000, the value that the carrier is getting from not having to pay benefits, and you would multiply that by 35.33%, and the attorney's fees associated with the $150,000 credit is $53,000. If the carrier's future medical benefit of not having to pay $60,000, that's going to be their future benefit, not having to pay $60,000, how are we going to figure out the attorney's fees associated with that benefit?
You multiply that by the 35.3%.
Perfect. Okay, same thing. So we know the carrier's future benefit for the medical, from not having to pay medical, is the value of that is $60,000. Carrier doesn't get that benefit for free. They have to pay for that benefit. And they pay for that benefit in the same proportion that everybody's paid for everything all along here. Okay, total costs, the percent of the cost to the gross settlement was 35.33%. To enjoy a $60,000 benefit of not having to pay medical, the carrier pays for that by multiplying the $60,000 benefit by the percent cost of litigation of 35.333%. And so the attorney's fees associated with the medical benefit are $21,200. Now, how does the carrier pay for that benefit? Well, if it's known at the time of the recovery, then all the parties should pay for their known benefit at the time of the third-party recovery. So since in this example, we're assuming that we know what the future indemnity benefit is, and we know what the future medical benefit is, and we know what the carrier's lien was, we're going to have the carrier pay for the attorney's fees associated with its benefit at the time of the recovery. And the way the carrier is going to pay for that benefit in this example is they're going to reduce their lien not only by the attorney's fees associated with the lien recovery, they're going to further reduce their lien by the attorney's fees associated with their future benefit. So they're going to further reduce their lien by another $53,000 because that is the attorney's fee associated with the credit that they're going to get for future indemnity. And they're going to further reduce that by another $21,200, which is the fees associated with the credit for the medical it's not going to have to pay. And so the carrier then recovers $22,800. And now the carrier has fully paid for its entire benefit that's going to get from this third-party action. Okay? So that's, if you know, you can figure out, and this is why we spent so much time in the last couple of weeks asking everyone to think conceptually about who or what is benefiting from the third-party recovery. And remember, we said sometimes the claimant and the carrier can recover, and sometimes it's just the carrier who can recover. There's only one time when only a claimant would recover from a third-party action, and can you tell me when that would be?
I can't.
No, because it shouldn't happen. The only time that would ever happen is if you didn't retain M.A.D, or the only way that only the claimant could benefit from the recovery on a third-party action is if the carrier waives its credit and its lien recovery. Why would you do that? Don't do that.
Now, what happens when the claimant settled without consent and the carrier did not know?
Excellent question. Do you know the answer?
No.
Oh, so Section 29 requires a claimant to obtain consent prior to obtaining a recovery. And that's because of everything we just talked about, because the carrier can benefit from the third-party recovery. So you can't consent to a settlement of a third-party action without the carrier's consent. If you do, you lose your benefits. You lose all your workers' comp benefits.
Have you seen that happen?
Absolutely. So it's a huge issue if a plaintiff, it's actually malpractice. If a plaintiff's attorney settles a third-party action without the consent of the carrier, it can prevent their client from ever getting benefits again, and that sometimes leads to an action nunc pro tunc, which kind of means like after the fact, for a plaintiff to obtain court approval of a settlement after the fact. So sometimes, and there's the requirements for a plaintiff to file this kind of a motion. It's laid out in the statute. And so there's a procedure that a plaintiff will have to follow in order to get a court approval of a settlement. If for some reason they didn't get the carrier's consent, or the carrier refuses to consent. The problem was if the carrier is refusing to consent, it's generally because they want part of the settlement that they're entitled to receive, and the plaintiff doesn't want to give it to them, and so they're going to go to court, and the court's going to rule and give they should. If things go the way they're supposed to go, the court should give the carrier all the rights that they're entitled to under Section 29, which would be its lien recovery and a credit. Okay, let's take a look at an unknown benefit. Okay, in some ways, if the benefit in the future is unknown, it could make it easier because you don't have to try and figure out what the future is going to hold. But if the future benefit each party is going to receive isn't known at the time of the third-party settlement, you cannot determine how much of the cost the carrier is going to have to pay and how much of the cost the claimant's going to have to pay. And that just makes sense. Like if you don't know how much you're going to benefit from a third-party recovery, how can you pay the attorney's fees or the costs associated with that benefit?
Isn't that Burns?
It is. You're so smart. I thought it was Brown or something.
Oh, yeah.
No.
That was really impressive.
So when in a situation where the benefit isn't known, then what you can do is you can have the carrier pay for the costs associated with the benefit as the benefit is realized. We call that a pay-as-you-go, and the famous seminal case which held that this is the way that costs should be paid when a future benefit is speculative is the case of Burns versus Variali. Let's take a look at some examples. Okay, we have this is the situation, right? So a Burns situation arises where you have a gross settlement, you know the disbursements, you can figure out what the recoverable lien is going to be because you just figure out the percent cost of litigation and you multiply that by the amount of the lien, and that way you account for the fees associated with the lien recovery. But what you don't know is what's smack dab there in the middle of our example. You don't know future indemnity, you don't know future medical. Okay, so in that situation, the carrier just gets back its lien recovery is its lien less the percent cost of litigation. So it's essentially usually about 2/3 of the lien. Not going to be exactly a third if you know what your disbursements are, because you're going to have an exact percent cost of litigation. So in our example here, it's I think identical to our last example, but if we have attorney's fees, it's a 1/3 contingent fee arrangement, and we have disbursements of $12,000, then the total cost in obtaining that recovery is $212,000. That, as a fraction of the gross recovery, is 35.333%. Okay, so our percent cost of litigation is 35.33%. So in order for the carrier to enjoy its benefit of $150,000 in lien recovery, it has to pay for that benefit. To pay for a $150,000 benefit, you multiply $150,000 by the percent cost of litigation, which in this example is 35.33%. And the cost associated with the carrier's recovery of its $150,000 benefit, its $150,000 lien recovery is $53,000. That's subtracted from 150 is $97,000. So in this case, if we don't know what the future indemnity is going to be because the claimant's not classified at the time of the recovery, and we have no idea what the future medical is going to be because there's a surgery or something that could be pending, then you would just pay as you go. Slide. To pay as you go in a burn situation, you just, whatever the benefit's going to be, you multiply that by the percent cost of litigation. So your burns payment, when somebody's referring to a burns payment, what they're referring to really is your payment of attorney's fees associated with your exercise of a credit right following a third-party recovery. So if you have a $900 weekly benefit that you would otherwise have to pay, but for this third-party recovery and the claimant putting a big chunk of change in their pocket, if you otherwise would have to pay $900 a week, and if it's a 1/3 contingent fee arrangement from the recovery, so your percent cost of litigation is 33 1/3, then you should have to pay $300 in an attorney's fee on the recovery, right, against a $900 credit. So to figure out what your fees are associated with the benefit, you just multiply it by the percent cost of litigation. So if it's a $900 credit that you're being able to take advantage of, you have to pay the attorney's fees associated with that benefit, and so you multiply the benefit by the percent cost of litigation, and that's what you pay. Basically, you're repaying the claimant for having prepaid the attorney's fees. Okay, because the claimant bears the 100% of the cost of the attorney's fees up until it becomes the carrier's benefit, and then you're basically reimbursing the claimant for having paid the attorney's fees in the first instance, because that was real money that went to the attorneys. Out of that $600,000, the claimant didn't get $200,000 of it because that went to the attorneys. So the claimant at the time of the recovery, if the future benefit's not known, the claimant has borne all of the attorney's fees associated with the recovery, except for the attorney's fees that the carrier paid, and they're getting their lien recovery. Similarly, if you have a $6,000 MRI and your percent cost of litigation is 33.33%, how much of the attorney's fees is the carrier going to have to pay for exercising a $6,000 credit?
$2,000.
In our example here, assuming a 1/3 contingent fee arrangement, no disbursements, your percent cost of litigation is 33 1/3%. You're enjoying a benefit of $6,000, so you have to pay the attorney's fees associated with that benefit. You multiply the benefit by the percent cost of litigation. Your fees associated with a $6,000 credit are $2,000. So that's all burns is just calculating how much of the attorney's fees you have to pay in order to enjoy the benefit that you're receiving. So in a situation where it's just going to be a $900 CCP, you're just going to continue paying $300 a week. Okay? But you don't want to forget things like, how could you avoid having to pay $300 a week? Settle, or you could raise defenses, like you could still pursue fraud, you could pursue labor market attachment, you could, if the claimant's return to work and there's an increase in the wages that they're earning, you could request payroll to see whether or not you could reduce the amount of the weekly benefit that it basically is eating away at your credit, because you want to preserve as much of the credit as possible. So my recommendation is don't set and forget your cases where you're doing a burns payment. Make sure that you're continuing to evaluate those cases to see whether or not there are any potential cost savings that you could have. Otherwise, you're going to end up paying again before you want to. To settle a Burns claim, then, all you need to do is to value your future exposure, right, and look at what your future benefit is going to be from having a credit, and then deduct the percent cost of litigation. I shouldn't have said from your lien. It should have said from your future benefit. Okay, so to settle a Burns claim, what I want you to do is to value the indemnity, just like you would on a normal case without a third-party action. You're going to value your indemnity, you're going to obtain an MSA or a medical cost projection or whatever mechanism you use in order to be able to value the medical on a claim. And then you're going to take your future exposure, limited by the credit. Don't forget, like if you only have a $150,000 credit and you have a $500,000 future exposure, don't give the claimant a Burns payment on $500,000 because you're not getting that $500,000 as a benefit. You're only getting a benefit of whatever amount the credit is. Right? So, but to calculate, to settle a Burns claim, all you have to do is take your future exposure, limited by the credit, multiply it by the percent cost of litigation, and you can then deduct that from any lien that you have at the time of the recovery. That's how you pay for it. Right? And then you can add or collect money depending upon the credit. So some situations, your lien might not be enough to pay for the attorney's fees associated with your future benefit, in which case you might want to kick in a little bit extra money in addition to waiving your lien in order to settle your case. Other times, your lien will be sufficient to not only your lien will be sufficient to pay for the attorney's fees associated with your future credit. Let's take a look at some examples. That'll make it easier. Okay, assume that the date of accident isn't really important, other than I wanted people to know that this is an example where there isn't a presumption about the 130 weeks of payments being your temporary partial payments, and then payments after that being presumptively permanent payments. So date of accident is 2/26/13, and CR is left hip, left knee, left hip, left hand, left thumb, low back, and neck. This is from an actual example, which is why it's so many body parts. But I also wanted you to see that this is definitely a classification. This is cases moving towards classification. At the time of the recovery, the third-party recovery, indemnity payments have been made of $100,000 and medical $50,000 for a total lien of
$150,000.
Excellent. The average weekly wage is $900 per week. The claimant hasn't been classified or anything yet. There's no MSA or anything yet because medical treatment is in flux. But there's a $1.5 million settlement. Okay, so is there a way? Anytime there's a recovery from a third-party action, it's like that is a prime time to try and settle your workers' comp claim. And so these are our facts that we're going to work with. Slide. All right, so this is a slide where I presented this again to show you the way you're going to settle a case with a potential Burns contribution is that your future indemnity is known, your future medical is unknown. So this is where you guys, like with your knowledge and experience and being able to value and settle claims, you can make good arguments for what the future indemnity of the claim is going to be like. You know, if the claimant's saying, well, I want a Burns contribution based on an 85% LWEC calculation, and you say, like, no, your guy is a PhD, he's only 38 years old, and according to the attending physician, he's got an A severity ranking impairment with respect to his back. And so you're going to say, like, no, I would do a Burns calculation based on a future indemnity benefit of 350 weeks, 325 weeks at a lower rate. Okay, so you use your skill to value the future indemnity and to value the future medical. All right, so in our example here, the way you're going to settle your Burns third party, your workers' compensation case at the time of a third-party recovery, when you have a future Burns contribution, you're going to do your analysis just like you would do on any case. Let's take a look at a specific example. Slide. Let's assume that you have a case where you valued the future indemnity is going to be $200,000 and the future medical is going to cost you $60,000. So it's like a 400-week case at a $500 per week rate, and the medical is like $2,000 a year for a 30-year life expectancy. All right, your gross settlement's $1.5 million. Assume we have no disbursements for simplicity here, okay? So what's the attorney's fee going to be on a $1.5 million settlement?
$500,000.
Assuming the 1/3 contingent fee arrangement, the attorneys at the time of settlement are going to get $500,000. So then what's available in net proceeds to distribute to the carrier and to the claimant?
$1 million.
There's $1 million available. Assume a lien of $150,000. How much of the lien should the carrier get back?
The 50,000? No.
That's the attorney's fees?
200,000.
No. The
100,000.
Yeah, the attorney or the carrier's lien recovery should be $100,000. They have to pay for the benefit of recovering a $150,000 lien in the same proportion that the costs are to the total settlement. And in this example, the percent cost of litigation is 33 1/3. It's 1/3 contingent fee arrangement. And so to recover a $150,000 lien, the carrier has to pay $50,000 of that lien. So the carrier is going to get back $100,000 in lien recovery. If you assume future indemnity of $200,000 and future medical of $60,000, then your total future benefit, your total credit in this claim is $260,000. Your Burns payment on that amount would be 1/3 of $260,000, or $86,666.67. And so in this example, you're negotiating with plaintiff or claimant's attorneys. You say that the future indemnity is only worth $200,000, the future medical is worth $60,000. You would reduce your lien your recoverable lien of $100,000 by the $86,000 in future Burns payment or attorney's fees associated with your future credit, and you could settle this case for a lien recovery of $13,333.33. So you're still getting some money back, and you get a full and final settlement. Hopefully this is making sense. Let's take a look at another Burns and a third-party settlement example. Same basic premise, $1.5 million settlement, so the fees are $500,000. How much is available for the carrier and the claimant to share?
$1 million.
$1 million, okay, because the attorneys get paid first, and then the carrier's lien gets paid second. All right, so if the carrier has a lien of $150,000, what are the fees they're going to have to pay associated with recovery of that benefit?
$50,000.
Which means they'll get back $100,000. Now I'd like to everybody to assume that our future indemnity benefit is bigger. It's much bigger. It's $350,000. This person is dramatically injured. They're going to get high LWAC at a high weekly rate. And their future medical is $100,000. So their total future benefit, potential benefit actually, is $450,000. Is there sufficient credit left available for the carrier to enjoy its full future liability that it may have on this claim?
No.
There is, actually.
There is?
Yes. If there's $1 million available.
Oh, $1 million.
Right.
Okay, yes.
Okay.
Sorry.
Yeah, no problem. So if there's $1 million available, and if you repay the carrier their $100,000 lien, that means that there's $900,000 available in credit. So even though in this example there is significant future liability, potential liability for the carrier of $350,000 in indemnity and $100,000 in medical, there's a sufficient credit available on this claim in order for the carrier to enjoy its full, not having to pay its future liability at all. So in this example, the carrier's future benefit is $450,000. What are the attorney's fees associated with that benefit?
$150,000.
Great. And how did you figure out that the carrier's costs associated with a future benefit are going to be $150,000?
Multiply it by the 33.3%.
Exactly. Okay, so if the carrier's future benefit, if we know that we've come up with an estimate that the carrier's future benefit from the calculations that we've done is going to be $450,000 that they're not going to have to pay, then the costs associated with that future benefit are $150,000. Okay, so now the problem is we have $100,000 in lien available, but $150,000 future benefit, or $150,000 in attorney's fees due on a future benefit. How do we settle this one? We're going to waive our lien, right?
Right.
So there's $100,000. We have $100,000 available to pay for a future benefit of $150,000. How can we come up with the other $50,000? We'll pay it as part of the 32.
Right.
Right. Okay. So in this situation here, where we didn't have enough money in our lien in order to be able to account for the attorney's fees associated with our future benefit, then we're just going to cough up some money like we normally do. But we're also going to waive our lien. So instead of having to pay, out of pocket for the whole thing, you waive the lien of $100,000, and then you come up with an additional $50,000 in benefits. And that could be how you would settle this particular claim with future liability of $450,000 for $50,000.
Is.
All right, and that is because of the third-party action, right? I mean, in many situations, there is no third-party action, and so the carrier's stuck paying $450,000 into the future without any benefit at all. It happens to be that if there's a negligent party that caused the carrier and the carrier to be injured because they have to pay money for their employee or their insured's employee who got injured, then in that situation only, there's a potential for the carrier to obtain a recovery against another party. And that's as it should be. Like, why should the carrier not be able to go after a negligent third party who caused their employee harm?
Right.
So, and that is the principle behind third party actions. So I think that we're at the end. Yes, we are. So hopefully this was helpful. Hopefully going through some examples and actually working with a calculator and doing some concrete math and talking about how we're paying for benefits has been beneficial to you. We will, of course, have another Lawyers and Friends next month. I believe that it will be Vicki Bueller and Neil Diegelman. It should be a lot of fun. Mm-hmm. And in the meantime, if you have any questions, please feel free to reach out to Melanie or to myself. My email is mday@madwcdefense.com, and Melanie's is close.
Daly at madwc.com.
Exactly. So thank you very much for tuning in, and we'll see you next time.
Thank you.